Hello, I am Dr. Angela Daly. I am an assistant professor in the Chinese University of Hong Kong Faculty of Law, for those who don't know me already, and I have been leading this project on 3D printing and intellectual property futures, funded by the UK Intellectual Property Office over the last 18 months. I'm sorry that I'm not with you today in person. Unfortunately, this week is the first week of the new academic year here at the Chinese University, so I have to teach my students instead, or at least teach them their first class instead and not miss that. But I'm sorry not to be with you in person. If you are going to attend the launch event of this project, I will be there and look forward to meeting you or seeing you again for those of you that I know already. So sorry that I'm not there. Instead, I've made this video to give you a bit of an overview of the legal component of the project's research, which I have also been leading, as well as the project overall. I'm going to give you an overview of the state of the field when it comes to legal research on 3D printing and intellectual property, some relevant findings from the workshops that we have done, or the empirical part of the project, and I will also highlight the relevant recommendations from a legal perspective. I think it's important to note at the beginning that this project is novel in a couple of important ways. So, as you may be aware already, there's very limited empirical socio-legal research on 3D printing. And in fact, the Intellectual Property Office has been a real pioneer in this field by commissioning research such as our own, and also the research done by our predecessors, particularly Professor Danusha Mendes, on 3D printing and IP. So it's important to highlight that this research is very novel because it adds to this very small existing body of empirical research on 3D printing and IP. Another major novelty of this project as well is the fact that we have conducted empirical research, and also to some extent legal research, in new places for empirical socio-legal research on 3D printing and IP. So in particular, Russia and various Asian countries. The limited research that exists already is mostly concerns countries in the West, and particularly in the English-speaking world. So the US, Canada, UK, Australia, and there is also some English language literature on 3D printing and IP in the European Union more generally. But there's very, very limited research of any description on 3D printing in other countries, and particularly from an intellectual property perspective. So we view this research as being highly novel because of the fact that we have done work on Russia, Singapore, China, and India. So, getting to the substance of the legal research, as I mentioned at the beginning, I'm going to firstly talk about what the state of the field is in legal research on 3D printing prior to us conducting the empirical part of this project. So the first stage of this project was to conduct a literature review in legal research, in social science research, and also in business research. So I am just going to highlight a few of the kind of important features of the current body of research. So we are seeing kind of a growing body of literature on the interaction of intellectual property law and 3D printing. However, much of the scholarship that we've found so far focuses on the position of jurisdictions in what you could call the global north or the west. The countries and jurisdictions I already mentioned, so US, UK, Canada, Australia, and to some extent other EU countries or jurisdictions as well. The position of other jurisdictions is highly under-researched, and we found very, very limited or almost no literature in some cases on those jurisdictions. In addition to this, much of the existing literature on 3D printing and intellectual property pertains to copyright and patents, with the literature on other IP rights, such as trademarks, design rights, and trade secrets, being much less developed, even in the context of literature from the US or the UK, for instance. Another feature of the literature so far is that it's largely theoretical and very academic as well. So as mentioned before, there's very little empirical research from a socio-legal perspective, which is borne out by the fact that we didn't find very much else out there apart from the pre-existing IPO reports, essentially. So again, I mean, we felt that this made our research in this area even more justified because when we actually looked for other research, we found very, very little. So just to kind of summarize, much of the existing literature is on copyrights and patents, and it's also mostly coming from jurisdictions such as the US, UK, Australia, Canada. When it actually comes to kind of the substance of the literature on copyrights and patents, as we kind of knew already, there's a lot of discussion on issues both by authors within the same jurisdiction, but also across jurisdictions on topics such as subsistence of rights, exceptions to infringement, identifying infringement itself, and liability regimes, particularly secondary or intermediary liability regimes, both across the different rights, that copyrights and patents are different, also across jurisdictions. So the view in the US may be quite different to the view in the UK on some of these matters. And as I mentioned before, there is disagreement by authors in the same jurisdiction on some of these topics as well, or precisely what ought to happen. As mentioned, there's much less literature on issues on IP rights, such as trademarks and design rights, and actually very little on trade secrets, despite the fact trade secrets seem to be gaining in importance in the 3D printing industry as a means of protecting information, confidential information. Interestingly as well, when it comes to design rights, there are some who have viewed that 3D printing would be a very important development for design rights, and design rights would sort of come into their own then, but they've actually so far received very limited attention, at least in the academic literature, and to some extent I think as well in the media reports or practitioner literature as well. In terms of IP enforcement, this has also been a topic of discussion in the literature, and various authors have discussed different kinds of enforcement mechanisms in the 3D printing process. So, for instance, applying digital rights management to 3D printing machines, the design files and software, suggesting that companies opt for some certain kinds of IP licensing schemes, such as file streaming applications, in order to kind of better safeguard their IP. Encrypted files and encrypted connections has been another suggestion, and some too have also discussed the possibility of imposing a private copying levy on 3D printers. Some of these enforcement mechanisms are being utilized already in practice, but in terms of legislation, none of these are kind of mandated as such. In addition to this, there is some literature on certain industries, specific industries, use of 3D printing and IP issues that have come up around that, particularly when it comes to the medical industry and bioprinting. Quite a bit of discussion around patentability, particularly of the products of bioprinting. There's also been a reasonable amount of discussion about the use of 3D printing in the field of fine art and antiquities, particularly kind of the scanning of objects, for instance, and IP issues associated with that. The use of 3D printing in libraries, which has become quite popular in many countries, and also food printing. So the use of 3D printing to print food, what IP issues, and in fact product safety issues may arise from that. As I would like to emphasize, this literature is very theoretical. There's not very much literature on actual applications of 3D printing apart from what I just mentioned, and also the discussions around different IP rights applying to the 3D printing process is very theoretical, because we've seen very few examples of cases actually coming to court on 3D printing and intellectual property issues. The cases that do exist, which have mainly taken place in the US, with a smattering of these cases taking place elsewhere. Most notably, there's one case that happened in China. Most of these cases concern patents regarding 3D printing machines and printing processes, so usually disputes over patents or patent infringement proceedings. In my view, these cases are not particularly challenging or controversial from an academic perspective, and are quite straightforwardly resolved in comparison to the concerns raised in the theoretical literature around 3D printing and IP. Generally, they don't address or otherwise clarify the various issues around topics such as for instance, identifying infringement or identifying defences to infringement, intermediary liability, and subsistence of rights. These tend not to be these topics, which have provoked a lot of discussion in the academic literature, have not really been addressed by this litigation, because, as I mentioned, I think they're kind of fairly straightforward cases around patentability and also patent infringement. Which, from an academic perspective, is somewhat frustrating, given that these issues or ambiguities in existing IP laws as applied to 3D printing exist, and we don't really have this clarification from the few cases that have come up. And we also haven't seen any specific legislative reforms to deal with these ambiguities either. Just to conclude on the literature, some of the legal literature has also looked at the kind of potential future scenarios for 3D printing and IP. So from at one end, some authors see 3D printing as an existential threat to the IP system that we have at the moment, because of the possibility of decentralized manufacture, use of design files downloaded from the internet, and so on. So a kind of Napster scenario for objects some view could be a possible future scenario more generally for IP, and in that case the IP laws that we have at the moment are kind of wholly inadequate. There are other kind of future scenarios as well, such as the kind of other extreme perhaps is IP rights holders trying to stifle innovation through 3D printing by lobbying governments and other legislative bodies for stricter regulation of 3D printing and 3D printers, which obviously could have detrimental effects from an innovation perspective as well. But there are other kind of potential futures. There could be another future scenario whereby legislators actually weaken existing IP rights, particularly patents, such as shortening the patent term, which could give rise to kind of more innovation or more innovative uses of what would otherwise be protected by patents. Some authors, particularly from the US, advocate for regulatory forbearance to allow kind of what they call permissionless innovation. And there are some other authors as well who don't really think there's going to be a very big change from the present situation, where we have IP rights, we have some measure of infringement, and we try to draw a balance between the kind of competing interests of different groups, which I'm sure some don't find to be a particularly adequate balance, but it is a kind of attempt to take account of different interests. So some people think that that sort of fudged scenario might continue. And also other authors have looked on their horizon to 4D printing, where you have objects that may change shape in time as the fourth dimension, and what the kind of IP implications may be for that. But that's a very kind of new area. 4D printing is a very new area of research, and accordingly, from a legal perspective, there's very sort of little on that. But this may be an area for more work in the future as 4D printing becomes more of a reality and utilized more. So I'm now going to kind of skip to some of the findings of the empirical work that we did, and recommendations that are relevant to law, or to intellectual property law and policy. So as you know, we did empirical work in the form of horizon scanning workshops in a number of countries internationally. And as we have been analysing the data and drawing findings from it, we have come up with some findings that are very relevant to intellectual property law, practice, policy. So in the different countries that we looked at, we do see a number of similarities regarding the relationship between 3D printing and intellectual property. So, for instance, most of the countries we've examined have to some extent implemented government policies to stimulate innovation and new technologies, including 3D printing. And as well, so far, in none of the countries that we've examined does 3D printing appear to be posing fundamental practical challenges to intellectual property rights and enforcement at the current moment in time. And this is due to a number of factors. There's still not very widespread take-up of 3D printing at the consumer level, and the more prominent uses of 3D printing are in kind of more centralized and industrial contexts where perhaps there is greater adherence and knowledge of intellectual property rights. But we think another important factor at the moment may be the kind of increased level of respect for IP rights in some of the systems that we've examined, which can be attributed to reforms to IP, particularly in the case of China and Russia in the last kind of few years, and also changing consumer preferences in some of the emerging economies in particular, where it may be a kind of sign of status to actually have and afford legitimate products and services rather than illegitimate infringing products and services. And particularly in China, there are very big concerns around product safety, particularly for food and drink and medicines, but product safety more generally as well. So it may be that by buying kind of official products and services rather than ones that may infringe IP or pirated or counterfeit copies or whatever you want to call them, that consumers are happier with that because they view that those products are more trustworthy from a safety perspective. Another kind of finding from the empirical research is that intellectual property is far from the only area which 3D printing brings up in terms of laws. And in fact, for those kind of operating in the 3D printing industry, IP may not be their kind of principal legal concern. Other areas of law, such as health and safety regulations and sector-specific regulations, particularly in medicine, may be more important issues or even barriers for those trying to get their products to market, more so than intellectual property. And uncertainties around the application of these areas of law may be impeding the creation, application, utilization of 3D printing innovations, particularly in the medical field. But nevertheless, IP is not unimportant for 3D printing. I think this can be seen definitely from the amount of patenting being carried out in the 3D printing space, such as the accumulation of patents around 3D printing, particularly by the US and China. Again, the expiry of patents was also widely pointed to in our workshops as an important event for the dissemination of 3D printing in various countries. Additionally, the possibility of more IP litigation was raised by participants in some of the workshops as well. So going to the recommendations, we have kind of just pointing to two major recommendations which very much kind of concern the law and legislative process from our work. So while we still don't think there is a kind of pressing need from the 3D printing industry and the 3D printing ecosystem more generally for reform in this area, we actually do recommend greater legal clarity going forward, which we've not seen through the cases that have come up or through other forms of kind of government intervention on this topic. In the UK, of course, we seem to be facing a potential hard Brexit scenario where perhaps we may have to have a very big reform to laws in general, including intellectual property level laws, sorry. And if that is indeed the case, then this may be a good opportunity to reform IP laws in order to kind of deal with some of those ambiguities that we have already identified and others have identified in intellectual property law in the UK when confronted with 3D printing. So we actually do recommend legal clarity in this area, and we do think that the appropriate actors should be working towards legal clarity, which may well come through legislation, and Brexit may be a good opportunity for that. Additionally, as some of you may be aware, the European Parliament recently adopted a resolution on 3D printing, which included the possibility of the EU adopting new laws or modifying existing legislation to address some of the IP and civil liability aspects of 3D printing. And it's our recommendation as well that Brexit, hard, soft, who knows, or not, the UK should follow the progress of this process and consider aligning any revisions of its own laws with the outcome of the process, if indeed that is viewed as being suitable and appropriate. So thank you very much. If you have any questions about the legal aspects that I've just spoken about, please feel free to get in touch with me, and I'd be very happy to answer them, or wait till we do the launch event and I'd be happy to address some of those questions then. So thank you very much.